rape allegedly committed on 6 May 2025 against a 20-year-old female, Ms. Mandisa Msani, and 2 sexual assault allegedly committed on 17 March 2025 at the SAPS Training College in Pretoria West against Ms. Bomikasi Tumisa. This is a Schedule 5 matter in terms of the Criminal Procedure Act 51 of 1977, and the onus is on the accused to satisfy this court that the interest of justice permits his release. B. Defense submissions. The applicant denies all charges and intends to plead not guilty. He raised exceptional personal and health circumstances, including chronic bronchitis, sinusitis, and back pain with muscle spasm. He alleges that continued detention adversely. Let me paraphrase. He alleges that continued detention adversely affect his health due to limited access to appropriate medication and diet. He has no previous conviction or pending matters, has served 31 years in the SAPS without disciplinary or criminal infractions, and his passport expired in 2008. He has never traveled outside South Africa. His affidavit discloses fixed assets in South Africa, a co-owned home valued at 700,000, a motor vehicle valued at 300,000, and household contents estimated at 150,000. He earns 25,000 per month, supports a wife and 3 children, and has no assets abroad. He further submitted that the allegation of intimidation and interference with the investigation are speculative, unproven, and not supported by any affidavit from complainants or witnesses. He asserts that appropriate bail condition can mitigate any perceived risk. C. State's opposition. The state, through the investigating officer, (IO), opposes bail on the basis that the accused poses a flight risk, being close to retirement and having a previously undisclosed passport. He is an influential SAPS captain who could interfere with witnesses known to him through the academy. The offenses were allegedly committed against vulnerable trainees using authority to intimidate or silence them. The IO testified that the complainants fear the accused and may be at risk if he is released. The IO further alleges that unlicensed ammunition was found at his residence, although no charges related to that are before this court. The state argued that rape is a prevalent and serious offense and that no bail condition will adequately prevent the risk posed. D. Issued considered flight risk and passport. The investigating officer testified that she was informed by the accused that he did not possess a passport, and she expressed surprise when, during defense submission, it emerged from the accused affidavit that he had in fact previously held one, although it had expired in 2008. The defense correctly argued that it is not the duty of the accused to assist the investigating officer in conducting her investigation, and that the IO could have, but did not approach the Department of Home Affairs to verify the passport status. The accused voluntarily disclosed this expired passport under oath in his affidavit and stated he has never traveled outside of South Africa. The state did not produce any evidence of a valid passport pending travel plans or any steps taken by the accused to abscond. On this basis, the court finds that the flight risk concern based on the passport issue are unsubstantiated, and the accused's conduct in disclosing the expired passport does not support a finding that he is dishonest or attempting to evade trial. 2. Intimidation and interference. The IO's testimony regarding the complainant's fear and the accused's alleged potential to interfere was based on hearsay and speculation. No affidavit from the complainants or any other state witness were submitted in support of this concern. The accused has no proven history of interfering in investigation, and the court accepts that condition could be imposed to safeguard complainants and witnesses. 3. Employment status. The court notes that there was no evidence or submission that the accused has been formally suspended from duty at this stage. Nonetheless, in terms of Section 60 of the Criminal Procedure Act, the court may impose appropriate bail condition to mitigate the risk of interference and ensure the integrity of the trial. Conclusion: in order, the court is satisfied that the accused has discharged the honours under Schedule 5, has deep roots in the jurisdiction, no travel history and no passport valid for travel, has no criminal history, and the charges, while serious, are unproven allegation at this stage, will not evade trial or pose a real risk to the public or to complainant if proper conditions are imposed. Accordingly, the court finds that it is in the best interest of justice that the accused be released on bail subject to the following strict conditions. Order 1. Bail is granted in the sum of 8,000 rand. 2. The accused shall not contact directly or indirectly any of the complainants or potential state witnesses. 3. The accused shall not return to SAPS Training College, Pretoria West, unless permitted in writing by this court. 4. The accused shall report twice weekly to the SAPS station nearest to his place of residence, Mondays and Thursdays between 600 hours and 1800 hours. 5. The accused shall surrender any travel document in his possession to the investigating officer within 48 hours. 6. Any violation of this condition may result in immediate revocation of bail. Thank you. Matter may be postponed.